What happens if you refuse to answer questions during your pretrial question and answer session known as a deposition in a medical malpractice case? You want to know what happens? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The short answer is you can be compelled to answer questions by the judge. And you may be saying, I don't care about the judge. I'm not going to answer certain questions. Well, if you take that position, there are a number of things that the judge can do, a number of options that the judge has, the most serious of which is to dismiss your entire case. Now, you might be saying, how is that possible? You, in your heart of hearts, know that your doctor was careless. You know that the injuries you have now are because of something that was done wrong. And in fact, you know that we've had a medical expert review your records who actually confirms that yes, your doctor was careless and that his carelessness caused you harm and injury, and that your injuries are significant and permanent. So now we go through the beginning stages of the case. We get your medical records reviewed. A medical expert confirms that you have a valid case. We tell you that we are starting a lawsuit on your behalf, and we explain to you who it is that you are going to be suing. So now, as we go forward, we tell you we have to exchange your medical records with the defense attorney. We have to provide him with permission slips so that the attorney for the doctor can go ahead and actually get copies of your medical records directly from the doctor's offices and directly from the hospitals where you were treated. And you're saying, okay, that's fine, that's fine. And now we also tell you, listen, during the course of the lawsuit, you will be questioned by the attorney who represents the doctor or the doctors whom you have sued. That's known as a deposition. That's a question and answer session given under oath, and in pre-COVID times would take place in our office, in our conference room, and I would be there, you would be there, the defense attorneys would be there, and there would be a court stenographer there to record all of the questions that you are asked and all of the answers that you give. Now, you should know something important. The answers that you give in this pre-trial question and answer session actually represent your sworn testimony. Oh, and by the way, during COVID times, this deposition takes place on a Zoom video call now. The answers that you give represent your sworn testimony, and it carries the same exact weight as if you are testifying at the time of trial in court in front of a judge and in front of a jury. So now you turn to me and say, well, there's some questions I will never answer. And I say, really, what are those? And now you proceed to tell me. Or alternatively, you say, I'm not going to share that with you. You'll have to take your chances and see what it is that I'm going to be asked, and I'll decide whether or not to answer those questions. And my response to that would be, no, that's not how it works. That's not how any of it works. You, as the injured plaintiff, the injured person who is now seeking to obtain money as a form of compensation for all of the harms and losses and damages that you incurred, now your life and your medical condition becomes an open issue, which means the defense has every right to explore and to learn about your medical issues. They have every right to probe into your background. They have every right to learn about who you are, what your educational background is, what your training is, as well as the facts of what brought about this particular case. If you decide, for whatever reason, that you are not going to answer certain questions put forward by the defense lawyer, you are going to get yourself in a great deal of trouble. So here's what will happen. During the deposition, the defense lawyer asks you a question. Let's say it's a question about, hey, Mr. Jones, have you ever been convicted of a crime before? And let's say you have been convicted of a crime. And you believe that this defense lawyer is never going to learn the correct or the true answer to that question. And you decide to say, I'm not answering that question. Turn around and say, you're violating my rights by even asking or suggesting such a question. And now we get into a heated battle between the defense attorney and myself. And I pull you out of the room. I say, listen, this lawyer has every right to ask whether you have ever been convicted of a crime. He cannot ask whether you've been arrested. He can ask if you ever pled guilty to a crime, but he has every legal right to do so. And you turn around and say, I don't care, Mr. Oginski, I'm not answering that question. It's going to open up a whole can of worms. And I say, if you don't answer that question, it's going to open up an even bigger can of worms, and it's going to get you in a lot of trouble. So, you are adamant. You refuse, up and down. I don't care what you guys do. I am not answering that question. Okay, so now the defense attorney is going to do one of two things. Either he's going to stop his questioning right then and there, and call the judge, which he probably won't be able to get a hold of, or he's going to stop the deposition and say on the record, look, because your client is refusing to answer questions that I am legally permitted to ask, I have no choice but to bust this deposition. And I am reserving my right to continue forward. And in the meantime, I am now going to ask the court for permission, written permission, to hold you in contempt or for various other options that I have available to me. So you say, you go do whatever you want. Let's see what happens. Attorney does exactly what you told him to do, what he told you he would do, which was make a formal written request to the judge to take action. To take action because he asked you valid questions, and even I agree that those are valid questions, and now you're refusing to answer them. So now the first line of attack is the judge says, Mr. Plaintiff, Mr. Injured Person, you are required to answer those questions that are legally permissible, and even your attorney agrees this question or these series of questions are legally appropriate. I compel you to answer the question, and you are now scheduled to have another deposition on the following date. Okay, so now we all get together again on a Zoom video call. The defense attorney starts off by asking you, hey, Mr. Jones, have you ever been convicted of a crime? And you say, I'm asserting my Fifth Amendment right not to answer the question. Well, guess what? You've got a problem, because this is not a criminal case. In fact, you are required to answer the question. It's either yes or no. And there are different strategies for learning how to deal with that particular answer if the answer really is yes. Okay, but now you've put yourself in a bind. You're still refusing to answer. So the defense attorney could continue forward asking other questions, which is what he should do, and then circle back with the judge and now explain further that again you refuse to answer those questions. Regardless of which option the defense attorney chooses, he's now going to go to the judge and explain why you are again refusing to answer proper questions. At this point, the judge has additional options. Because of your refusal to answer questions that the defense attorney is entitled to learn about, now the judge decides to punish you, to sanction you, and that could be in the form of a monetary fine. If he feels that I am collaborating with you and preventing you from answering that question, he would then fine me and sanction me, which is very, very bad, because that word gets out that an attorney has been sanctioned for failing to do certain things that the court ordered. That's a problem. Word gets around. So now you still refuse. What happens next? It simply escalates the options available to the judge, where ultimately, if you still refuse, the judge could, in some limited circumstances, turn around and say, okay, Mr. Plaintiff, you have willfully ignored my order. You have refused to answer a legal question, a legal series of questions. Now I have no choice but to dismiss your entire case. If you don't like it, take it up on appeal. So what have you done? What you've done is, for whatever reasons you have, you've chosen not to answer specific questions that even your attorney has determined were legally appropriate for you to answer. The better practice for you is to answer the question regardless of what the answer will be. Now, assuming it's truthful. You don't want to answer something that's not truthful, because telling a little white lie, thinking that the defense won't know about it or learn about it, will get you into hot water again and can likely cost you your case. Because in these cases, credibility is everything. So again, the judge has multiple options available should you continue your refusal to answer appropriate questions, and it's a position that you simply don't want to be in. So why do I share this with you? I share this with you because you may get the sense that there are certain things that you feel it's not appropriate to answer by the defense attorney. And the only person who can really reach that conclusion would be your attorney to tell you whether or not you should answer those questions. And if you disregard your attorney's advice about those questions that he tells you to answer, now you put your case in peril. And now you subject yourself to fines and sanctions and penalties and possibly even getting your case thrown out. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Oh, there's a beautiful bird of prey up there. It's gorgeous. Looks like an osprey. Well, that's it for today's video. I'm Gerry Oginski. Have a fantastic day.